We'll call the meeting to order. This is Matt Rands. I'm here with my fellow board members of the State Board of Real Property Tax Services. It's June 14th, 2023. We've got Scott Becker and Sam Casella, who are our board members, as well as Joseph Gerberg, who's our legal advisor to the State Board, and our new interim director and acting secretary, Rachel Ingleby. Is that how I pronounce your last name?
Ingleby, yes, very close.
All right, well, welcome. Nice to meet you virtually.
Nice to meet you too, and thank you.
All right, thank you. All right, our first item on the agenda is looking at the minutes from January 31st, 2023 board meeting, which were distributed in advance.
Mr. Chairman, I reviewed the minutes and I've moved that the board adopt them as written.
I'll second that.
Okay, all in favor? Aye?
Aye.
Aye.
All right, the minutes are approved and adopted. Next, we have the state full values and assessment, final franchise full values and assessments for the 2023 assessment rolls where complaints were filed. How do you want to present these and group them?
I'm going to turn it over to Ed Martirana of our Valuation Services Bureau to present these.
Great. All right, welcome, Ed.
Thank you. Good morning. We have 5 companies who have filed complaints with a total of 13 complaints. I believe we have only one company being represented who's present. Would you like to start there?
Yeah, that makes sense.
Yeah.
The company is Optical Communications Group. I think we have the representatives there. Right, is that Mr. Morris and Mr. Ickes and Anna from the company?
Good morning. Thanks to the board for having us here today. Yes, we have members of the company of Optical Communications Group here today, as well as myself, Jesse Mars, who will be representing them today.
Great, welcome. Thank you for being here.
The company Optical Communications Group has filed 4 complaints, SF 23-3, -5, -10, and -14. The complaints are all identical in nature, so we'll address them as all as one, and they are identical to previous year's complaints, with the same calculations being provided. The complaints request between a 68% and 92% reduction in all the affected municipalities. These complaints contend, at the time they were required to submit their inventory, a representative from ORPS agreed to excuse OCG's failure to file and agreed to rely on OCG's inventory from a prior year. ORPS is not permitted to excuse any utility company from the filing requirements, and only rarely allows extensions to file for circumstances beyond the control of the filer. The ORPS representative was identified during a hearing on May 4th, 2023 by the company, the principal, Brad Ickes, as being Jeremy Krugel. Jeremy Krugel, who is the representative said from ORPS to excuse the company from filing. Mr. Krugel testified at the hearing that he had not spoken to Brad Ickes or any person from the company in all of 2022, and analysis of his phone records could also demonstrate that. Additionally, the company was provided a filing reminder containing all the forms and templates necessary to file on March 23rd, 2022. That was sent to all utility companies throughout the state of New York. ORPS is not required to send that, but we do so in order to achieve voluntary compliance. Additionally, a delinquency notice dated June 1st, 2022 was sent to Mr. Ickes, who responded by forwarding the delinquency notice to other personnel in the company. No other response was ever received. On October 6, 2022, second delinquency notice was sent to the company, leaving no doubt as to the expectation that the company was expected to file, never excused from doing so. The company contends that the ORPS estimates are incorrect, and they provide a purchase order and an invoice, one purchase order and one invoice from a different company, BI, a sister company, demonstrating that the cost per foot to install their system is said to be $1.80 to $2.25, inclusive of all costs. We know that this is absurd from the data that we have from other companies of a like kind who file in New York City and who have the same business model as Optical Communications Group, that is, companies who install their own inventory. Additionally, we know that their application is incorrect. If we look at the board materials on page 1066, as an example, you will see that the company takes a $2.25% installation cost, and in the year 1999, they trend that to a $4.10 being today's cost. Yet, in 2011, they take that same $2.25% per foot cost and trend it to only $3.06. So in other words, they contend that in 1999, it's $4.10, yet in 2011, it's only $3.06 per foot to install this infrastructure, so it's 75%, which is obviously absurd. No costs in 12 months have reduced by 12%. A little history about this company. The company's been in business since 1998. Yet they were only discovered by ORPS in 2014. That is, they had never filed a property tax for 16 years. When they were discovered by ORPS, they were discovered in only being in Manhattan. And at that time, the company never came forward to indicate that not only were they in Manhattan, but in all 5 boroughs of New York City, as well as in Long Island. That was discovered by ORPS in 2019. Additionally, in preparation for internal hearings this year and for the board, we find out that not only are they in all the boroughs of Manhattan and Long Island, we only know of 346 route miles. We have found it published that the company has over 720 route miles. We know some of it's in New Jersey, but we don't know how much, and the company refuses to find us the route data necessary for us to determine exactly the mileage in New York State. The values for the company were estimated as it was required because we had nothing from the company but a scant couple of invoices, which represent nothing of their original costs. We determined a composite value based on data that we have from companies of a like kind that operate in New York City under the same business models as Optical Communications Group. That is, companies who are self-installers of their infrastructure and who rent poles and conduit.
Assessor's office, may I help you?
In the company. We also did an expense analysis and determined that the company far exceeds the value they contend of about $2 million or so, that their expenses are much greater than that for just the materials they purchase. It was contended, well, they do work for other companies. No invoices or any data to demonstrate that has ever been provided. They claim that they do not have any inventory of their, any invoices or data for their original costs. Yet they failed to provide us any financial statements or any other data that they would have, including audited financial statements, which would be requisite of any company of their size. Staff recommends no change to the special franchise value determined for this company. The complaints are all addressed in Resolution 23-12.
All right, thank you. Do you have any questions, any of the other board members, or we can hear from the representatives of the company?
Tom, I'll wait to hear from them.
And me also, thank you.
Okay. Mr. Morris, do you want to start?
Yes, thank you very much. I appreciate everyone's time this morning. I appreciate you giving us the opportunity to present our position and to take it into consideration as you reach a decision today. I do know that this has been before the board in previous years, so you may be familiar somewhat with this. I'm not sure that we've appeared before. And I think that this year we've done some things differently as we've, learned from past experience. So I appreciate you allowing us to make this presentation on behalf of Optical Communications Group. I'll call it OCG. Just by way of brief background, OCG is a small but well-established company. It provides competition in the telecommunications market, which is much needed. We need competition in the market. We need it and we all know this whenever we're faced with choosing a company to give us high-speed internet service. We all know as consumers, there's usually only a couple options. OCG is one of the few independent companies out there that's been providing communities with choice. It provides internet service not only to residential consumers in multiple communities, but also government agencies, educational institutions, fire departments, police departments, data centers. Their customers include the New York Unified Court System. It includes the New York City Board of Elections, includes the New York Housing Authority, NYU, the U.S. Marshal Service, and the Department of Defense, and many others. The way that OCG can compete and provide service. For starters, they rent conduit from bigger entities like Verizon, Con Ed, the people who have the incumbent presence in the city and in the state generally. They run fiber optic cable. OCG runs its cable through their conduits into the communities that are today the subject of this hearing and the subject of the complaints. New York's Appellate Division has explained that the ultimate purpose of evaluation is to arrive at a fair and realistic value of the property involved, a fair value and a realistic value. No one disputes that OCG should be required to pay its share of taxes, but that share should be fair and realistic, as the court noted. OCG isn't Verizon, it's not Con Ed. OCG's limited property at issue here consists of fiber optic facilities in a handful of municipalities and the city. The department has valued the property that we're here today about in a total amount of $25 million. So the issue is whether the board should arrive at a fair and realistic valuation, and the answer is yes. And how do we do that? The correct method of valuating special franchise property is reproduction cost new, less depreciation. It's RCNLD. In the matters before the board today, OCG based its proposed calculations on its cost without depreciation. And what's interesting about that is the calculation that we provided is strictly a function of the original installation cost adjusted upward by CPI. That means our valuation was actually higher than it needed to be. And yet it's still a dramatic reduction from the department's numbers, which I'll talk about. OCG's limited costs are the way in which it competes against the big companies. For instance, it typically doesn't use third-party installers. It has an affiliate called BMI, which is an installation company, which doesn't just install for OCG, it installs for others, including Verizon and its affiliates. So to show the correct installation expenses, OCG provided the department with cost figures at the same time for the same kind of installation for this kind of equipment installation. And we didn't provide ones that were specific to OCG. It was the higher cost. It was the retail cost. That's the cost that we're relying on. Now, this is the one that we just heard a moment ago from the department is an absurd figure. Well, why is it absurd? What leads to the conclusion? Is there a competing number? If so, what is that competing number? I will tell you that in all of our complaints and in all of the hearings we've had, we've never heard a competing value. So the board is presented with a figure which is the actual retail installation cost versus an arbitrary number that has never been explained. It certainly hasn't been explained to OCG. The installations, most of them at issue, took place 17 years ago or more. The costs that we supplied don't include 17 years of depreciation that OCG could have accounted for. But our resulting valuation across these matters without depreciation is 3.7 million. And just to remind you, that's compared to 25 million, which they've been assessed with now. The difference of over $21 million highlights the excessiveness of the department's valuation. And again, we have never been presented for the basis for that calculation. What we heard just now from Mr. Martirana is that he went to others in the industry and he looked around. Who, what, where do these numbers come from? We've honestly never been told other than that he believes it's true. Well, hopefully there's a better basis for that to arrive at, again, a fair value and a realistic value. It has to be realistic, and we've provided a competing number based on not just realistic, but actual retail installation costs. So unless the $25 million assessment has some basis rationally connected to the property, it's not fair and it's not realistic. I think that what happened here, in part, and the board should be aware of this, I think it's based on history. I think that Mr. Martirana actually raised that. He talked about 2014, that, you know, his view is that things were discovered, that the OCG didn't come forward and disclose things. We dispute that, but we're not disputing it here for today because it's not relevant for today. The fact of the matter is that OCG disclosed things in 2014. It wasn't caught doing things, but it doesn't matter. What matters is that we're here for 2022. We're here for what information is before the board in 2022, not what happened in 2014. So I understand that there may be resentment or other kinds of issues going back that far, but that's not the way you do a fair and realistic valuation. We need to know the facts. We also heard in a number of these hearings a talk about 720 miles of cable that OCG has. 720 miles of cable is not an issue in this case. OCG provides service in New Jersey. We're not here for New Jersey taxes. We're here for a certain set of municipal entities in the city of New York, and that's the limit. And whatever other numbers Mr. Martirana believes in, at least it needs to be supported. And the fact that OCG has come forward and put in supported numbers seems like the fair and realistic answer. Now, one last point, and I know that this has been a focus also of the hearings because I appeared at them. A lot of this goes to technical alleged violations like timeliness. The answer to this is the reporting requirement, for instance, doesn't present an absolute bar to relief, especially when the failure was due to circumstances beyond the control of the complainant. This has been something that's gone back and forth with issues due to staffing and COVID at OCG, and they have made communications with the department in order to deal with the fact that some of these reports couldn't be done. But at bottom, any error in that area is harmless because we all know what the numbers are. There's no dispute about what the linear feet are or what the installation cost is. If there is, let's not punish based on a technicality. Let's find a fair and realistic valuation. I understand that there may be technical ways to bypass this, but the point of this should not be to punish OCG and threaten its existence as a competitor in an important market in New York. The important thing here is to get a fair calculation and not let the technicalities of a missing report one year be the answer to these complaints. The property at issue, as I said, was installed 17 years ago plus. It's a known quantity. It hasn't been modified. There were no updates to give in 2022. So rather than find ways to short circuit this matter, let's get a fair and realistic determination. And I hope that the board would say, if we're going to do 25 million instead of 3.7 million, what's the rational basis? And if there is one, that's a different story, but we haven't seen that. I thank you all very much for giving us this opportunity to present this, and I welcome any questions that you may have for me.
All right, thank you very much. Questions from the board?
So my first question directed to Mr. Morris is, I'm interested to know, exactly what type of evidence and where it's submitted that you have to support your number that results in the 3 million figure as opposed to the 25 million figure.
Sure, thank you, Mr. Becker. So these are all in the materials for today. You'll find them submitted with each of OCG's complaints. I can try to direct you to one, or I can just speak about them more generally. But
is it the $2.25 figure? Is that it, or is that something different?
Yes, there's a $2.25 per linear foot installation cost. And there were multiple ways in which this was shown, but the primary method was to show invoicing either at the same time or for the same type of installation, showing what the amounts are charged to third-party entities to show a retail installation cost.
Okay, so I'm looking at a purchase order. This is attached to, for my fellow board members, SF 2303. This is attached as Schedule B. There's purchase orders today to you, to OCG, from Sumitomo Electric Lightwave. Are these purchase orders what you're referring to, or is there something different?
You'll have to excuse me. I'm looking for that.
Oh, sure. And then I see on the next page for Exhibit B, there's another thing that says BMI Technologies. There's another invoice. I just want to be sure that I'm looking at the right numbers for you and trying to establish whether or not you've met the initial burden to establish, your valuation. I guess the point, maybe you could address the bigger point, Mr. Morris. I understand that it's frustrating that the department might use a figure that you feel that there's no support for, but would you agree that you have the initial burden that we presume that their number is correct? Would you agree with that?
Absolutely. I believe there's a rebuttable presumption, and that's our burden.
Okay, all right. So then what I'm trying to do is trying to weigh, the evidence submitted to see whether or not, that creates enough of a rebuttal to that presumption to require the state to come forward with the other evidence. I'm trying to figure out exactly which of these invoices that it comes from.
You're looking in the correct place, and these invoices show installation costs. BMI is the affiliate I mentioned earlier. BMI doesn't invoice OCG directly, and in fact, if it did, as affiliates, their numbers may not be as what I would say is a fair installation value versus a retail installation for the purpose of valuation. So what we have in the invoices for BMI shows BMI's third-party installation rates, and then these are applied to per foot linear footage numbers, which have been submitted as well.
Understood. And then, okay, now I'm seeing it now. Thank you. You've trended these up based on CPI, and there's no other market survey or anything, is there?
That's correct. It was done with a straight CPI increase over 17 years.
All right, Mr. Morris, thank you very much for answering my questions. You did so very ably. Thanks.
I appreciate it. Thank you.
Sam, do you have anything to add?
Yes, I'd like maybe the department's response to some of Mr. Morris's comments. If I have this correct, sir, you said something about the fact you felt that the department's competing values were arbitrary. Were they arbitrary by the department, how they came up with it, and you question what was the basis being used? Can the department address that?
Yes, I'd like to note a few things about the purchase order in the invoice. First, Mr. Morris stated that the company doesn't use any third-party contractors, yet they provide a purchase order demonstrating the exact opposite. Additionally, that is a purchase order, not an invoice. We never know if they actually receive those services or not. Then, for the sister company BMI, they provide an invoice saying that they did work for Empire City Subway. Empire City Subway is a monopoly in Manhattan. If you're going to have any infrastructure, you have to rent conduit from them. Additionally, half of their business is installing infrastructure. Any infrastructure that BMI installed would have been in the furtherance of OCG. They wouldn't have done that on behalf of Empire City Subway. Additionally, they were involved with a lawsuit with Empire City Subway for various reasons. We don't know if that invoice was ever even paid or whether it's the accuracy of that. When you look at the costs that they have, it contradicts exactly what they're saying. They say, well, all the costs are included here. It's $2.25 for rotting and roping. Yet we know there are far more costs involved to install the infrastructure. For instance, permits, engineering, licensing fees, insurance, overhead, equipment, etc. We know from an expense analysis that the company has expended over $35 million for just subcontractors, which they claim not to have used, and materials. When we look at other companies of a like kind that operate within New York City, who install their own infrastructure, everyone in New York City rents poles and conduit, except for the giants who own them. When we look at their infrastructure, we see it is far greater than what OCG is contending now. And we know that the costs that they're stating are absolutely unrealistic, and that the value we have is understating what they're saying. And they failed to provide any substantive documentation, even though we've requested it for years, including financial statements if they don't have their invoices or the original costs they incurred. I think that when we look at in the totality of this business, it's most likely we are way underestimating the cost of the infrastructure. We know that they have 720 miles of infrastructure, and that they would know every route, every duct, the fiber count in every line they run, and we know they would have that data. They would need that. That would be necessary for them to keep the system up and running and to know what's available to operate on. Yet they will not provide this to us, so we have no choice under the law other than to estimate their cost, and we've done so using a likely more than fair value. It probably underestimates based on what we see of other companies of a like kind that operate in New York City.
And could you speak to our calculation methodology?
So our calculation is based on the footage that we know about. It's a composite that we worked up a number of years ago when they were discovered. And we took that from the other companies to determine what other companies have per foot, and we multiply that by the footage that we know of, that we estimate, because we don't actually know their footage. We only know about 346 some odd route miles, and have never been provided the complete system maps to determine conclusively what the actual mileage is. But we take our composite value and multiply it by the foot that we know of to achieve our value in the install years, which the company contends of the install years, and we depreciate those to determine their end value. So we take, after we determine the per foot times the mileage they have, we deduct depreciation for the presumed install years to come up with the estimated value for the company by jurisdiction, which we believe the infrastructure is in.
Okay.
And incidentally, was also verified through an expense analysis that we have. We know they've extended far more than the $25 million in the expenses that would definitely be included. That is subcontracting, materials, and other overhead costs that would be includable to the cost of the system.
So there is
some of
data that you, I'm sorry.
I'm sorry, go ahead. I spoke out of turn.
No, I'm sorry. I just was going to just clarify. So there is data that the company could provide that you guys have requested, or that you'd be able to request, that would, if they wanted to justify the valuation that they're contending, that they could put forward.
Yes, we've requested audited financial statements, for example. That would say what the cost of the system is that they carry on their books. They would definitely have these for financing purposes and other reasons. Additionally, they certainly have a far vast number of bills that they pay for the operation and the construction of their system. The idea that they lost those all just does not seem reasonable. We've requested that data many times.
And those are typically provided in similar instances by similar companies.
Oh, well, yes, it's necessary. We request that data and are able to ascertain the costs that they have. The idea that roping and rotting are the only things that go into the system is an unfounded statement. There's far more that goes into it. And any company that didn't report original cost, we would seek other data to determine the cost of the system when any such system was installed.
Okay, thank you. Scott, go ahead.
So my question was, it relates to the miles, the miles issue and the fact that there are some miles in New Jersey. And you referred to a figure that OCG had spent in excess of $25 million. Do you know, is that just on the miles that are at issue here today, or could it also be related to property that's outside of New York State?
We don't know. We've never been provided their route maps to say what their system is. And also, we can't, the sister company does a lot of work, BMI, that's a solely owned company by the same principal as this company, Brad Ickes. They also have a considerable number of expenses, so we don't know which expenses that company would contribute to this system as well. Or if there's even other companies out that are also operating under the same principal, Brad Ickes, which also have costs. So it's undetermined.
Thanks.
Sam or Scott, other questions? Or I was going to ask Mr. Morris just if he had any response as far as, is there data that the company could provide to, you find that fair and realistic valuation that I agree everybody's looking for?
Yeah, thank you. Thank you for the opportunity. There was so much there that I don't want to overstep my response too far, but well, let me start by saying OCG has provided the department with route maps. And I don't know, I don't have everything in front of me as far as what's been submitted, but if there's a question as to the linear footage, that's one issue. And if we say, and by the way, our inventory is set forth in all the complaints. So the linear feet for each of the communities is set forth. If there's a dispute about one or more of those, because it doesn't match up with the maps we provided, or there's some other basis, okay, that would be a dispute, and we would be in a position to resolve that. And the same goes with installation cost. I understand Mr. Marano's argument, which is that he believes, although we haven't seen the basis, but he believes that things should cost more than what we're paid here. The purpose of using a retail agreement with BMI, and it's no secret, he mentions that it's an affiliate of OCG. We presented that fact. That's not, again, this isn't being discovered about OCG. This is their affiliate that they use for low-cost installations. But that retail amount, which is being charged to a third party, such as Verizon or ECS, and again, I don't want to dispute everything, but no, it's not for OCG's use. Sometimes it does work for other companies. But when BMI does a retail agreement, that number that they charge captures all the costs that we care about. If there's a permitting issue, it's captured. It's a retail cost. It has to cover, it's covering BMI's installation overhead plus a profit. So that's the number. And again, if there's either a linear footage dispute because this or that number in Garden City Park, New York, is wrong, okay, we'll have that. Then we can get into a numbers discussion. Or if the rate that X other company is paying is well above what we're paying, and it breaks down like this. Okay, well now we've overcome the rebuttable presumption, but the department can come back and say we're wrong because, and then then we're about meeting the burden. But we've met the initial burden, and Mr. Marano has arguments against it, and of course, I mean that's part of his job is to determine these. But we can't prevail if simply his initial assertion without more is allowed to prevail over facts that we provide with a sound basis. And I apologize. I know there were other things that, I don't know if you asked me specifically about one of our issues, but I can speak to them if you want. I mean, just to give an example, Mr. Moderano referred to relying on a composite of what others have per foot. Okay, what composite? What others? Is it a big company like Verizon that does things differently? We don't know. And it's just about providing enough of a basis that once we overcome our presumption, if we have to do more work, we'll do it. But we can't fight against a sort of a phantom set of numbers. So I'll take more questions if I can be more specific. I don't want to run my mouth.
Scott?
Go ahead.
Yeah, this is basically for Ed. I had this in my notes, and Mr. Morris brought it up again. He says, what is the basis the department used? Was that basis made available or known to OCG? Mr. Morris alleges that it wasn't. Does that information exist, and was that information as a basis provided to the complainant?
Since the data is from other companies who are under the secrecy provision, we wouldn't be able to provide the exact data. But I might note one thing about the BMI invoice. That contradicts their contention. The work that BMI would have done for any other company is not only, that wouldn't complete any other company's system. But those companies who they contend they do work for would have a vast other costs that they would incur, not just for the rotting and roving. But we have requested their route data in detail, and they just will not provide it. So they want us to give them, they say, oh, well, show us where the 720 miles is, and then if we disagree, we'll let you know. And they're required to provide the data under the law. And in absence of providing the data, we have no choice but to estimate and are allowed to do so. But yet they keep on saying that we have to show them how they came up with the number and not the other way around.
Sam, go ahead.
Mr. Morris, I've heard that comment twice from the department. Are you aware that there's data you could provide and you've refused to do it, or do you feel you've not had that opportunity?
One of the issues that came up from the earliest of the hearings for this year has to do with the fact that some of the records that are being looked for date back to 17 plus years ago. There may be specific installation costs that simply don't exist anymore. And the question then becomes, okay, if we don't have an actual proof of installation paperwork from 2006, what can we do instead? And what we did instead was we provided a invoice from 2006 at a retail level to say, even if we don't have this, we do have this other thing. Now, obviously, going forward, any installations are going to have documentation that we'll submit each year. We can't go back and we're not going to invent something that we don't have. But we have used the best information at our hands. We're certainly not withholding anything. And if there's something else like audited financial statements that they want going forward, we can produce that if there's something specific in the data, I should say, that will provide more than what is already known. We'd be happy to provide, but we can only provide what the actual information we have. And I think it would be unfair forever to pick arbitrary numbers because a piece of paperwork is missing from that long ago.
So is there no there's no cost data since 2011, is that right?
I don't believe that there's cost data from 2006. Is 2011 one of our dates?
I don't know. There's something in the, what is this? Part 3 valuation, Village of Lake Grove, 2011, Huntington, 2011. There's a whole bunch in Brookhaven. Let's do 2011.
My recollection is that we did that whenever we supplied something that was a substitute, it was because it was the best evidence that we had of an install cost. Sometimes it was actuals. I think the the Sumitomo was an actual purchase order. Hang on, let me see.
I'm just looking at the addendum to your complaint. Let's see. It's got SF 2310 is the number. Exhibit part 3 of your addendum lists the valuation section. Just shows install years, and some are 1999 and some are 2011. My point is that there's no additional install data that OCG has since, for 2020. OCG didn't install anything in 2020, or whoever OCG's vendor is. OCG didn't pay to have anything involved installed.
There's something that was installed by Rooney Line, which is an invoice that we have.
What I'm getting at is if the valuation is supposed to be reproduction cost new, the older the information is, the less reliable it is to translate. The more you're making assumptions to bring it up to today. So something in 1999 or 2006 or whatever, that was a long time ago. So there's a lot of assumptions, and it's not necessarily as reliable as what evidence of a new installation or new cost would be in 2020. So it's just a question to me of like, what's the best way to determine, right?
Okay.
What's the cost new? And my question to you was whether or not OCG had anything more recent other than what was submitted here in terms of cost.
I understand your question. I appreciate that. We didn't do that, but I think I can certainly see if we have something like that to submit, and it would be a different calculation, but it would be essentially the same idea. It would be an actual install. And yeah, I don't see any issue with doing something in that direction.
Well, it just seems to me that on both sides we're trying to read shadows on the wall, right? And disagreeing about the approach. I just don't feel like there's any more concrete data here than which I think no matter what comes through this way, it sounds like the department's answer is going to say, well, that's still not concrete enough, and then leads them to their other processes. Is that correct, Ed?
Oh, okay, sorry.
If we had even more than a scintilla of evidence here to what their costs are, but everything they contend demonstrates that they're underestimating their cost by their own contention. So first, Mr. Morris said, well, we can do this so cheaply because we don't use third-party contractors. Then they provide an invoice from a third-party contractor.
Yeah, I understand the issues in terms of what's there. I guess I'm trying to figure out what could be there that would be compelling enough for the department to
Audited financial statements would help. How about their federal tax returns? Then we could look and see what Section 179 expenses they took and other expenses, and that will speak to their system. How about the invoices for supposed other work they did for others that OCG claims they did? Let's see some of those invoices. How would they get paid if they don't have those invoices or records of those invoices? We've asked for all sorts of data. All we've gotten is what you see. A few invoices that don't demonstrate much of anything.
Scott?
Yes.
Go ahead.
This might be down the same path. I'm just trying to get my arms wrapped around the fact that Ed had mentioned early on in his presentation that there's no documentation that goes back to the earlier years, and I believe, Mr. Morris, you mentioned 2006. Is that a critical component, Ed, for the department to have had some numbers, some information that was factual back in 06, 07, 08? Would that be some valuable information for the department to have?
It'd certainly be valuable, but any information demonstrating what their actual system costs, we could utilize. For instance,
Well, I guess where I'm going with that is, and this is just to Mr. Morris, you know, representing his client, it isn't, near as I can tell, sir, it's not the department's responsibility to come up with that. It seems like it ought to be OCG. I realize that history probably predates you. You don't look that old, sir. But it seems like there's some information missing that may not be had or could be compiled using comparable values back at the time. But I know we're going back to some basis, and I'm hung up on that word as well. I don't think that's the department's responsibility, and they're claiming they haven't got anything that's that definitive. Going back in time, going forward, I think you said this, sir, to your credit, things exist now in a very recent past. And this is really to the department, to Ed. Is that information, I guess you said it is valuable. I guess you answered that question. It seems like there's information and data missing, and maybe Matt mentioned that. I get the same impression that there's like something behind this that never was provided or the company does not have that information. It seems like that's part of the problem, the conundrum for the department to come up and even more evaluate their complaint. Am I missing something here, Ed, Joe?
you have it. They have not provided us any information. All they've done is verified the estimate of the mileage that we made. We made the estimate of the mileage being 324. They verified that and gave some locations they said it was in. That's it. Other than these scanned few invoices you see, that is all the information we've been provided, even though every year in writing we request data. And just recently, financial statements, for instance. Just give us those. We'll start from there. But
I'm sorry, Matt, one other thing that Mr. Morris made a comment in his opening comments. Obviously, he's representing his client, but I can't believe there's any sense of resentment by the department. He did say that. And I remember hearing about this before. I don't believe that's the case. I hope it isn't. I'd be surprised if it was. But that comment bothered me as well, that it looks like the department is trying to do its job and provide due diligence, et cetera, and address the complainant's concerns. But I never, ever got a sense that there would be any resentment by the department towards this applicant or anyone else for that matter. Looks like everybody's looking to get at the same end with more information to digest. But that's my opinion.
Sam, you're exactly correct. There's certainly no resentment on behalf of the department. We, like I think everyone on this meeting, are simply looking to reach a fair assessed value and need more information to do so.
So I think we should move the question of the resolutions provided to us, which I'm out of order. So which number are we covering this?
2312.
2312, which would accept the recommendations of the staff. I would move that resolution.
I will second that.
Any further discussion?
The only thing that I would want to point out is that I feel like the initial burden is on OCG to come forward with sound theory objective data to support its claim of overvaluation. And in terms of the number of miles, all that's that to me is not terribly relevant to what what we're talking about here. If there was a dispute, if there is a actual dispute on the number of miles, then I think that's something that OCG would have raised, and they're not disputing the staff's number of miles. So I don't see that really as being an issue. However, what I see as being the issue is how reliable, is this number, and whether or not it's sound theory and objective data to say, well, we're going to trend these numbers from so long ago up and just use this as the cost without considering depreciation. So that to me is, I don't feel that OCG has met its initial burden, which would require the staff to come back with proof of their values. So I'm inclined to agree with the two of you and agree with the motion. Approve the motion.
Thank you.
I'd like to thank Mr. Morris for the respectful way he's presented himself to this board. I very much appreciate that, sir. I realize there's quite a discrepancy here financially, and I appreciate your presentation.
Yes, I agree.
Thank you. Sort of what Scott said is there's too many gaps here in information that I honestly can feel why the department is struggling, if I can use that word, folks, at the department's end, to try to see their way more towards the applicant's concerns. I don't see how there's enough information. There's gaps of financials, gaps of past history, and I don't have half the information, although we've got it in two big binders, sir. What the department has been dealing with and struggling with, I just don't feel that the department was provided enough information, which they couldn't provide to us, to come up with the conclusion, but to support their initial findings. So I just wanted to make that fact known, sir. Thank you.
Thank you. Yeah, I would echo the same statements. Mr. Morris, thank you for presenting your case here, and I think everybody is looking to find that fair and realistic valuation, and it sounds as if there's frustrations on both sides that maybe we don't have enough information to look at. So there's seems like a path forward here if OCG can provide the department with some more clarity. Hopefully that we can get to a place where everybody feels satisfied. But with that, I'd like to just call a vote on the motion. All in favor, say aye.
Aye.
Aye. All right. Thank you very much.
Thank you all very much. Appreciate your consideration of this today, and I appreciate the careful thought you've given to it in discussing the issues.
Thank you. Have
Have
a
a
great
good
day.
day.
And we'll sign off unless you need us for further proceedings.
No, that's fine. Go ahead.
Thank you.
Thank you. Okay, so Ed, are you going to keep going? What's next?
Okay, we have Liberty.
Can we make sure if there's anybody else from any other companies that are on the line?
Good question.
Can you speak up if you represent another complainant? Okay. Who's Roseanne Lemery?
Roseanne Lemery, is that what you're asking?
Yes. Who do you represent, please?
No questions. I was just listening in.
Are you a member of the public or?
I am an assessor in the town of Fort Edward.
Okay, thank you.
Thank you. Welcome.
Thank you.
Okay, I guess we can continue on with Liberty Utilities Corporation, that was formerly known as New York American Water. They have filed 5 complaints, SF 23-1-2-4-6 and -7. All the complaints are identical in their argument, and they are consistent with the previous 4 years complaints. This is the 5th year in a row we've been before the board. The complaint contends that ORTS misused third-party indices. However, the company provided no explanation of the misuse, and the indices were applied with long-standing and widely accepted ORTS procedures. The complaint contends that ORTS failed to adjust construction and certain other costs. ORTS utilized, as is required, the reproduction cost knew less depreciation, starting with the original cost provided by the company, and were provided no costs that they said should be adjusted. The complaint contends that they object to the use of the fixed intangible value of 5%. The use of the intangible value is outlined in the ORTS procedures. It's considered reasonable. It's applied to all utility special franchise property within the state of New York, and it's been continually upheld by the courts. The complaint contends that insufficient economic obsolescence was afforded. The company was provided a 10% economic obsolescence in their service area 1 and a 30% economic obsolescence in the service area 2. The complaint objects to the use of a depreciation floor. The floor was applied in accordance with works procedures and is applied to all special franchise values for all utility companies and all municipalities throughout the state. The complaint contends that insufficient salvage value was applied. They provided additional information identical to the previous 4 years, but they failed to show how the use of salvage value would, how they calculated any value by use of their suggested salvage value. The salvage value utilized by ORPS was applied in accordance with ORPS procedures, and it's applied equally to all property of a like kind throughout the state of New York. The complaint contends that inadequate functional obsolescence was provided. However, the company had not requested functional obsolescence and has provided no calculations showing functional obsolescence. Liberty fails to calculate a value using the alternative methods they request and arbitrarily arrive at a 75% reduction in all jurisdictions covered in the complaint. The complaints also state that the ORPS value is unlawful, illegal, and unconstitutional. Those have been addressed by the hearing officer's report. Staff recommends no change to the special franchise value determined by the company. All the complaints are addressed in Resolution 23-11.
Okay, any questions?
No.
Do we want to move right to the resolution? This is 23-11, correct?
Yes, I move we adopt resolution SF 23-11.
I'll second that.
All right, all in favor? Aye?
Aye.
All right, thank you. All right, what's up next? Ed, you keep it on rolling, right?
Keep rolling. We have a Slick Network Solution Incorporated. SF 23-8 and 23-9. This company has been before the board before. They are arguing essentially the same arguments they previously argued, and both of these complaints are identical. The company contends that ORPS included work in progress and other costs incorrectly in determining their value. The value for special franchise determined for this company contains no work in progress, as the company has not provided, they didn't report any work in progress this year nor last year. The complaint also contends that grants should be considered economic obsolescence. The property of Slick was determined using the reproduction cost new less depreciation, and economic obsolescence can be considered a form of depreciation. The argument that Slick makes that grant dollars somehow represent economic obsolescence is unfounded. Additionally, economic obsolescence is a permanent impediment on the subject property, and the company has not demonstrated that any such permanent impediment to its value exists. They're not here to speak to how they actually calculated their values. I can't determine it. It's certainly not the 80% grants that they have. The values are determined all over the place. A question for another day, I guess. The complaint alleges that the taxability of fiber optic cable is unjust, and that's a legal argument that's been addressed in the hearing officer's report. Staff recommends no change to the special franchise value determined for this company. The complaints are addressed in Resolution 23-13.
Okay, I would move resolution SF 23-13.
I will second that.
All right, any discussion?
No, only that I believe the department has proved has substantiated that resolution, I think, beyond a doubt right now with the information I have in front of me.
Yeah, seems, I think that, I agree with that. So I'll call the question. All in favor? Aye?
Aye.
Aye.
Thank you. Okay, next is Bayonne Energy Center.
Bayonne Energy Center filed complaint SF23-12. They request a 15% reduction in Kings County, New York City. The complaint contends that construction and certain other costs failed to be adjusted in ORP's determination of the special franchise value. However, the complaint does not show any costs that they contend should be adjusted, and no costs were provided to ORPS that show any adjustments to their valuation. Their valuation was determined using the reproduction cost new method, starting with the original cost provided by the company. The complaint contends that the property did not receive appropriate physical depreciation. More specifically, they contend that the net salvage value should be a negative 43.23%, and that the account that they use, account 53, trans, underground, conductors, and devices, uses a zero salvage value inappropriately. The salvage value that was afforded to Bayonne Energy is applied to all property of a like kind in that location, equally for all property in the state of New York. The location of this property is in a seabed, and it would be unlikely that it would ever be required to be removed because it sits below the seabed by a number of feet, 4 to 18 feet. It would cause more ecological damage to remove the property than to leave it in place. It's governed by a number of agreements, some of which say that it's to be cut and capped and left in place. Others which say it may be required to be removed. So it's indeterminate. They are able to request to be able to leave it in place. We also know that the company has no intent to remove this infrastructure within its economic useful life. We know that because at the May 4th, 2023 hearing, they testified that they have no intent to add another transmission line into the state. They have no other lines into the state. And we know from the Bayonne News article 11/2022 that the company who operates Bayonne Energy Center, it's known as Tiger Cogen LLC, has entered into an agreement with Novo Hydrogen to convert one or more of their natural gas turbines in New Jersey to hydrogen, specifically for the purpose of supplying New York City energy beyond the 2040 zero emissions climate initiative proposed by the state of New York. The complaint further contains that our value is unlawful, illegal, and unconstitutional, and that's been addressed by the hearing officer's report. Staff recommends no change to the special franchise value based on this complaint. The complaint is addressed in Resolution 2315.
Chairman,
Yes, go ahead.
I will move Resolution 2315.
Okay, any discussion? Okay, all in favor? Aye?
Aye.
Aye. Thank you. Okay, did I go out of order there? So we have
Con Ed.
Con Ed.
One final complaint from Con Edison. Con Edison filed complaint SF23-11. The complaint only asserts that we should accept, quote, for reasons stated in petitions filed with the Supreme Court in Albany County, index number 905290-18. The arguments made in those petitions have all been rejected by the Supreme Court of Albany in their decision dated November 17, 2022. That's attachment C to the board materials. Their complaints have yet to been shown to have any merit. They contend that the Climate Leadership and Community Protection Act of 2019 and the New York City Local Law 97 of 2019 impede the value of their property. But Con Edison has failed to demonstrate how these enactments have impeded their property's value and has provided no data or calculations to show what it believes the correct value would be in light of only these initiatives. No other explanations or calculations have been provided by Con Edison, and they arbitrarily arrive at a consistent 50% reduction in all jurisdictions covered in the complaint. Staff recommends no change to the special value based on this complaint. The complaint is addressed in Resolution 23-14.
Okay, so let's consider 23-14.
I will move that we adopt that resolution.
I will second that.
Any further discussion?
Yes, I just want to say that I concur with the hearing officer's findings and the department's findings. I believe Ed, you said we've heard this before, haven't we?
Yes, quite similar arguments, which they have went to court on, and they did not prevail.
Thank you. And that's what I thought. And with no prejudice, I didn't hear anything new to change make me disagree with the hearing officer and the resolution as it's written. Thank you.
Thank you. Okay, all in favor of 23-14?
Aye.
Aye. Thank you. Okay, so our next, there's something here for Transcontinental Gas Pipeline Company in the agenda. Is that referring to one of these other complaints, or was that?
Transcontinental Pipeline has withdrawn their complaint.
Okay,
That's not here.
it was just in the agenda, so I didn't want to leave it in there if it was. I know it wasn't in any of the other materials. And then our next item is the store exemption appeals. Excuse me. So we have a number of appeals to consider. We'll go into executive session to discuss those. But in terms of general discussion, Joe, is that something you want to update us on?
Yes, Joe will be presenting these for discussion today.
Great.
What I'll do, I'll follow our usual practice, where in the open session, I'll speak briefly about the principles, and then when we go into the specific complaints, since that involves people's tax returns, that should not be discussed in public, so we have our practices to go into executive session.
Mr. Chairman, I move we go into executive session.
I will second.
Okay, so all in favor, aye?
Aye.
All right, we can stop the recording then. All right, so we've got a series of resolutions here. Do we want to take them one at a time? Do we want to take them in batches?
I'd like to move the one enhanced, if I could, and it's Resolution 2316, I believe.
Mm-hmm.
I'll second that.
Okay, any discussion?
No, I support the resolution and the department's findings for the enhanced denial.
All right, so we'll call the question. All in favor, aye?
Aye.
All right, so Resolution 2316. And then do we want to look at 17 through 24 altogether?
That's okay with me. Sam?
Well, it is. Do we have any interest in keeping I think it's 23-24 separate, or are we still just using the same findings? I have no problem blocking the bulk of them. I'm just curious. There are obviously 8, income issues. I guess I'm asking my fellow board members and maybe Joe and Ed, is that one with the federal implications? Should we treat that differently?
Joe, I guess.
They can be treated differently if you choose. This would not be a discussion, this would just be a vote.
Yes.
So if you'd like to break any of them out, that's definitely your prerogative.
No. In fact, I'm looking at my notes. I apologize, Scott. I think these are they're clearly income-based issues, and I have no problem if they want to be blocked.
Okay, so in that case, I move that we adopt resolutions 2317 through 2324.
I will second that.
Okay, all in favor? Aye?
Aye.
Okay, thank you, and thank you to everyone in the department for all the work resolving what are generally thousands of these STAR challenges that come through. Is that right, Joe?
Yes.
Yes, you see the tip of the iceberg.
Yeah, so the fact that there's so few that don't get resolved before they come before the board, the great work that the department does to try to resolve these issues for the taxpayers. So thank you.
Thank you. Our staff here does excellent work.
All right, any other further business for the board?
I just want to thank Kayla assembled this. Whomever did a great job. It's an incredible volume of information, and I literally could work my way through it. And very good job done with this information packet.
Yes, I agree. We have multiples of these binders, which quite a feat. So.
And by the way, Scott, I'm sorry, man. I'm hoping that Tim is enjoying his life now in the Bahamas. It's well deserved, and he's missed.
We miss him. Let me say though, I share your sentiments. I definitely missed him, but I think Rachel is an excellent replacement. She's a great choice to lead Orphans in the future.
And there was no reference to that. I sent an email to Rachel way back when. I'm sure she's going to do fantastic. Just it was a fond farewell to Tim. That's all.
I second that. I would if I had a vote.
There isn't a vote, Joe. All set on this one.
Yeah, that's great.
One additional item for the board, too. I just want to make you all aware that there is new legislation requiring that state boards have independent websites. Presently, the state board's website is a part of the agency's website. So we're working with our communications team to sort of extract that and make it its own independent website. Don't foresee terribly significant changes, but we'll be sure to pass that on to you all once it's finalized. I want to extend my thanks for your time and consideration of these matters. We greatly appreciate it, and I look forward to working with all of you.
Same here.
Yes, welcome to the department, and we look forward to working together.
Excellent, thank you.
So do we have a July meeting scheduled for equalization complaints? Have any been received yet?
July 26th. There are some. I heard some possibly in the pipeline.
None yet, but a few possibilities.
Mr. Chair, and I believe it's potentially July 26th.
That's the date that was picked, correct?
Okay, and I mentioned this at our last one. I will be in South Dakota and in North Dakota between July 11th and getting home midnight, July 19th for the state, the National Association of Conservation Districts. I'm our state president. So long as it happens after the 19th, I'm here. And that's what I've had done on the calendar.
That should be fine.
Right. What date do we have right now selected?
The 26th.
26th?
July, yes.
Okay, just want to make sure
It's November 8th.
All right, great. All right, so motion to adjourn.
So moved.
Second it.
All right, all in favor? Aye.
Aye.
Thank you, everyone. Have a great month. We'll see you maybe in July, if not November 8th.
Got it.
All right.
Take care, everyone.
Thanks, everyone. Thanks for your time.